note of it, and then take him back to that part of it and let him clarify. I want to thank all of you for coming on time. This is part of the training here. Please, can we all mute our microphones? This is part of the training, we're trying to inculcate into ourselves timing. Time, they say, is a language. So welcome, everybody. I must thank Aaron for your time. If I was to be paying Aaron, I'm sure I probably can't afford Aaron's time. So Aaron, thank you very much for joining us to build a new generation of seasoned and smart arbitrators. We're most grateful to you. So I'll hand over back to Kelvin, who would read your bio and then kick off the class. Thank you, everyone.
Thank you very much, Dr. Adeyemi. Mr. Aaron's bio. Mr. Aaron Ogletree handles hearings, motions, judicial reviews, appeals, and trial. He negotiates settlements in business law, real estate law, and criminal civil litigation cases. He advises clients on regulatory compliance and corporate governance matters, interview witnesses, review documentary evidence, and conduct record system survey. He developed and implements legal. He develops and implements legal strategies, implements and drafts contracts, and researches relevant points of law. Known for building constructive relationships with challenging clients, opposing counsels, and other law firms. Mr. Ogletree also mediates and arbitrates disputes across business, energy, property, and other areas of law. Ladies and gentlemen, our speaker for today, Mr. Aaron. You're welcome, sir.
Thank you. It's a pleasure to get an opportunity to make this presentation. You have an excellent person over your program, being Tolu, who's internationally recognized. So let's get right into it. So my program is Introduction to Arbitration, which is one of the tools in your toolkit. So in terms of resolving disputes, first you start with a dispute, and then you want fairness and justice. So today's agenda, we're going to be talking about what is arbitration, why arbitration, institutional versus ad hoc arbitration, protocols for expeditious and efficient arbitration, setting the stage for a successful arbitration, managing a preliminary hearing, final conference, and evidentiary hearing, award and past award issues or post-award issues, arbitration ethics, 20 mistakes arbitrators make in an arbitration, unconscious psychological influence in addressing them. So I know we're limited with time, so I'm going to try to go through the slides to give you as much of a foundation of arbitration as I can, time permitting. And if you have any questions, please feel free to stop me so we can have a good exchange. So what is arbitration? Arbitration is a private, legally binding form of alternative dispute resolution where a third party called an arbitrator hears arguments and evidence from opposing sides to render a final judgment. Why arbitration? Speed, efficiency, reduce costs compared to litigation. A skillful litigator can keep a case going in the United States for years. You can go through the initial court, then you go to the Court of Appeals, you can appeal to the Supreme Court, and sometimes you can keep going on. It can last for years. Arbitration, once the arbitrator makes a decision, if there's no ground to overturn it, pretty much you just file the arbitrator award with the court, and that's it. Discovery is far more streamlined. So unnecessary discovery can be removed from the process in time delays. Efficiency, confidentiality, and privacy. Expertise of the arbitrator. You can choose the arbitrator that's an expert as opposed to you just going to a court and whoever the the court assigns to the case, gets the case. You choose your own, narrowly tailored for what you and your client want, as long as the opposing side is okay with that choice as well. Finality, again, like I said before, if in litigation, a case can keep going on from appeal court to Supreme Court, at least in the United States and in Canada and other locations. And then flexibility. You can, as we'll see later on, the arbitration process is very flexible as opposed to the regular litigation process, which is very focused in terms of the way that they do things. And we're going to talk about things such as hot tubbing, which you will see later on. The parties can choose their own judges. And then arbitration also reduces court congestion. So, in terms of institutional versus ad hoc arbitration, institutional arbitration is arbitration managed by institution pursuant to its process and rules. So, for example, here in the United States, it may be the American Arbitration Association or JAMS, and the arbitrator gets selected through that process, and the arbitration is going to follow those rules. Ad hoc, a person may go to you as an individual, and you're not going through this tribunal. You're not going through. I mean, you're not going through this institution. They come to you, and you're the one who's in charge. And we're going to go over some of the benefits of ad hoc versus institutional from both sides. So the benefits of institutional arbitration: procedural fairness. You know what you're going to get from the very beginning because they have it laid out and have done it for many years. There's a buffer between the arbitrator and parties. Also, there's fund holding. So the third party holds the funds, as not just the arbitrator holds the funds. Administrative cause. So the arbitral institution will make sure that the cause are set forth, and the arbitrator just has to make sure that their schedule is compliant with that. And then the institution will also review the award that the arbitrator is giving, even though most arbitrator institutions don't interfere with the merit. Some arbitrator institutions do review your awards to make sure it's consistent with what their rules and regulations allow. And then there's also efficiencies when using the rules because it's already know what you're going to get uh, in accordance with those rules. In terms of non administrative arbitrations, what we call ad hoc arbitrations, cost, flexibility, and confidentiality. It's some of the benefits with ad hoc. Again, you just go to the arbitrator. They may just say, "Hey, I want you to serve as the arbitrator," and then you and the parties determine what rules that you're going to use and so forth, and administrate yourself without the third party arbitral institution making putting forth how it's going to be done. Protocols for efficiency and expeditious and efficient arbitration. One is to be deliberate and proactive, control discovery, control the motion practice, control the schedule, use protocols as tools, not as a restraint. Remember that arbitration is a consensual process. So there's two sides to the arbitration, and both sides have agreed to the arbitration. And so remember that. Setting the stage for successful arbitration. And this part of this presentation, we're going to be talking about the importance of the arbitration agreement, selection of the arbitrator, disclosure by the arbitrator, arbitrability, preliminary motions before the preliminary conference. The importance of the arbitrator agreement, the form of the arbitration, the number of arbitrators is decided by that. The delegation clause is a provision, as it says, a provision in which arbitrator agreement authorizes the arbitrator to decide questions of arbitrability as opposed to a court, and also can help determine in regards to the use of administrative agency and applicable rules. That's what the arbitration agreement should state. Does anyone have any questions so far? Okay, I'm going to go to the next slide. Setting the stage for successful arbitration, selection of the arbitrator, negotiating the choice of arbitrator. Then there's party appointed arbitrators, which normally, when there's a panel of three or more, the parties may select each side may select one arbitrator, and then there may be a third arbitrator, which is a neutral one. And then again, selection of arbitrator, one of the benefits is you get a chance to tailor it to the type of arbitrator you want. What type of background and experience does the person have? Is the person familiar with the culture that you want the person to be with? Is it have a very technical background? For example, some the arbitration may be in the insurance industry. You may want to have an arbitrator that deals with insurance. You may want to have an arbitrator that deals with construction. There's many areas of law, and you can tailor it to, in terms of your selection of arbitrator to what that specific dispute is. And make sure you do your due diligence in terms of selection of arbitrator. Disclosure by the arbitrator. You should conduct a conflict check, and the arbitrator should as well. You need to determine the proper scope of disclosure. Does anyone have any questions? Including social media, an obligation of each counsel to participate in the disclosure of the arbitration if they know information that's suitable. But disclosure by arbitrator is an ongoing duty. You may have a conflict that develops during the process of arbitration that you didn't have before. So it's ongoing in terms of proper scope of disclosure. There are some arbitrating associations that may say you need to disclose not only your own potential conflict, but say, for example, if you have a spouse or family member, otherwise than a spouse that could have a potential conflict, that may have business dealings with the opposing party. And we're going to get further into this during the arbitrator ethics portion. Arbitratability. The scope of the arbitration clause very much determines in terms of what can be arbitrated. You also need to look for the jurisdiction in terms of that clause as well. What happens with people who are not part of the arbitration agreement, non-signatories to the arbitration, and then applicable rules. These are all things you should be thinking about as an arbitrator. And as also, if you're a counsel, part of arbitration. Here's a couple of preliminary motions that you may see as an arbitrator, dispositive motions, motions that could be brought to try to end arbitration, whether fully or partly. An emergency or a motion for emergency relief or interim relief. Jurisdictional motions to say, for example, the arbitrator doesn't have a jurisdiction to decide this particular issue or the whole matter. Before the preliminary conference, you want to look at, because and from the client perspective, is the client going to attend the arbitration, the preliminary meeting, and also in regards to communication with the opposing party. Those are things that, as a counsel, you want to make sure that you decide before going to the preliminary meeting. From the arbitrator perspective, before the preliminary meeting, you want to create a checklist, have a proposed draft order that you can put forth and be able to modify as needed. You want to make sure you review both the file and the arbitration agreement. And also communication prior to the preliminary conference. Again, if you have an arbitrator institution involved in the process, then communication will be done primarily through that arbitrator institution. But if not, if you're ad hoc, then you would have to handle that or have one of your staff handle the communication with the parties beforehand to make sure the preliminary conference runs smoothly. Managing a preliminary hearing. These are some of the topics that we're going to discuss. What to do to get ready? How do you start the hearing? Discovery, motions, and other matters. Managing a preliminary hearing, what to do to get ready. Again, the authority and rules. Disclosure by counsel, witnesses, other party related to that potential conflict. Disclosure by the arbitrator, the appointment of the arbitrator, the oath of the arbitrator. Some institutions require arbitrator to make an oath swearing to the information disclosed, and they're going to manage the arbitration in a fair and effective manner. Authority to arbitrate. You want to make sure you get a copy of the arbitration provision. Determine the applicable rules and statutes. What to do to get ready. Review the documents on file. Pre-hearing communications. Is this preliminary hearing going to be in person? Going to be by video? Is it going to be by phone? Make sure you know who's going to attend. Identify your objectives for this preliminary hearing. How do you start? Introductions, preliminaries. For example, just each person introducing themselves and make sure you do a roll call and make sure you have everyone needed to move forward. Consider the preliminary questions you're going to ask. You've already had a presentation done before about mediation. Is that going to be a part of the toolkit you're going to use to say, hey, have you considered mediation before proceeding with this arbitration? You want to give the parties opportunity to give their statements. Because one of the things about arbitration, we want to make sure that the parties are heard and be able to make their case. Case management order. You have to consider, again, in terms of case management, where are you going to begin? And then consider the strategies, how you're going to do that. Managing a preliminary hearing. Develop a plan. Know the limits and ground rules. Are there going to be depositions? Are there going to be subpoenas? Are there going to be expert witnesses participating? Is it going to be e-discovery? Are there going to be protective orders needed in this matter? When you put in the work at the beginning, it makes the process much easier when you go to the evidentiary hearing and drafting your award. Motions, again, dispositive motions, interim relief, motions in limine, and request for permissions. Those are some of the motions that you may encounter during a preliminary hearing in terms of making sure that you want to know if the parties are going to be putting forth any of these motions moving forward. Again, case management order. You want to make sure you got the dates of when to make sure you move your arbitration in a efficient and effective manner, and try to stick to it as much as possible. The form of the awards. We're going to get into that a little bit later, but for example, there's interim awards, final awards. Then in terms of testimony, alternatives to direct examination and cross-examination. We're going to get into discussion with that a little bit later. Direct communication, joint exhibits. Managing the final conference. The basics. You want to make sure in terms of the hearing room is decided, technology, exhibit binders, daily schedule, and have a court reporter. Any special needs or circumstances to accommodate the parties. Also, in terms of managing final conference, bifurcation or division of issues, unlike in terms of a regular litigation where one side presents all their issues, the other side presents all their issues, each side gets their turn. In arbitration, you can do one issue at a time. You say issue A, the plaintiff puts forth their argument, then defense A, they put forth their arguments, and then you go to the next issue. It's not as restrictive as regular litigation. Also consider allocating time. And how are you going to allocate the time? Witnesses. Are they going to be in terms of direct? Or is it going to be written? Or is it going to be sequential? Or is it going, what witnesses are going to be secluded? If any are going to be secluded? What's going to be your evidentiary rules you're going to use? And then also consider motions and limiting. Exhibits. How are you going to consider objections? Or is all the evidence going to be omitted absent an objection? Are there going to be reports in lieu of direct examination? So you don't have to hear testimony. You just a reporter. You make the decision based upon that. The Daubert motion, as it says there, is a motion to exclude proposed expert testimony. Then hot tubbing, as we discussed before, hot tubbing is opposing experts testify simultaneously in a panel format rather than just one at a time for efficiency purposes. Managing an evidentiary hearing, expect the unexpected, to object or not. What happens if there's a surprise witness? What happens if there's new exhibits? The expert who strays beyond the report or his expertise. You have to consider where you're allowing too much cumulative evidence. What happens if one of the parties puts forth 4 or 5 witnesses to say the exact same thing when that same thing could be said by 1 or 2 witnesses? You have to also weigh the balance if you're allowing too little evidence, which could lead to the ward being vacated because the side didn't get the opportunity to present their case effectively. The arbitrator questions the witness. As an arbitrator, you also have to know if that's something that you wish to do. Does anyone have any questions so far? Anyone have any comments? Okay, I'm going to go to the next slide. Award and post-award issues. Types of award, standard award, bare bones, you win, you lose. That's it. Then there's what we call reason awards, which states the reason for the decision. Then there's interim decisions. A decision is made before the final word is reached. How about when attorney fees are stated? When to divide up interim award on liability, damages, attorney fees, and interest? Or is this all going to be wrapped into one final award? In terms of arbitration, this is an important thing to very much consider. In terms of your arbitration award, when it's a reasoned decision, you want to write it for the reviewing court and enforcing court to consider, but also, are you writing it for the parties? Remember, they're the ones at the beginning who had a great involvement in selecting you as the arbitrator. You want to make sure you explain your award so even the losing party can understand your award. You also want to make sure if you followed the law. Have you considered the equities? If you're part of an arbitrator panel, is there going to be a dissenting opinion in the award? Those are all things to consider in terms of written award. Here are some of the elements of a good reason award: an introduction, a statement of the arbitration jurisdiction, a statement of facts, procedural history, parties' arguments, analysis of each fact in defense, damages in award section. In arbitration, this is something that arbitrators sometimes disagree on about independent research about the law. What if a party doesn't cite an important case? Consider it from you as an arbitrator, but also here in terms of introduction to arbitration, we're also going to consider it from the advocate's perspective. What if you're on the other side and you later on see that case that's important wasn't cited or wasn't mentioned? Proposed awards and drafts. Do you circulate the award, the pros and cons? Do you copy and paste awards? And you look at, I mean, also consider the parties having a proposed award themselves. These are things you need to consider and weigh the ramifications of each. Arbitration ethics. So I want to pose to the group here. I have a couple of arbitration ethics questions that I'd like to hear from you about.
Maybe,
This is
mommy, please, maybe you are somebody.
this arbitration involves a dispute between two celebrities. The lawyer asked the arbitrator if a reporter can interview her client about the proceedings. Is there a rule that will prevent the arbitrator from granting such a request? So this is posed to the class.
I have an answer to this. You can just unmute the mic to respond. Thank you.
What do you think the answer is?
You have to buy out your salary. But for us to put things in order, we have to make it right. That is one. Two,
Please consider this question and tell me what you think. The answer is.
Oh, 70%.
Okay, Gloria, do you want to contribute to this?
Okay. Stephen, I see that you have your hand raised. Do you want to answer the question?
Yes, sir. Yes, sir.
Go ahead.
So I think the ethical issue here is on the confidentiality of the whole process. So asking the lawyer to comment. Okay, let me read the question. Is there any rule that would prevent the arbitrator from granting such a request? Yes, as an arbitrator, you must be confidential with the entire process. So, granting a request for an interview will jeopardize the confidentiality of the entire process. An arbitrator to grant interview.
Okay. I see Blessed has her hand raised. What are your thoughts? Go ahead.
Bless, you can unmute your mic. Okay, Mr. Aaron, I think you can continue. Or you want more contribution?
Okay. All right. Let's go to the next one. An arbitrator has a personal Instagram account. Please read the question or the pose. Said he does not disclose the lawyer appearing before him is listed as a follower on his Instagram account. If the arbitrator rules in the favor of that party, would that fail to disclose amount to evidential partiality? This again is posed to the class.
Okay, sorry, can I see comment on this?
Go ahead.
Okay, I think one of the ground rules in arbitration proceeding is setting out disclosure at the preparation stage rather. So an arbitrator must give full disclosure of every information that he knows in respect of that particular arbitration. And then parties to the arbitration must agree before the commencement of the proceeding, that is at the preparation stage. So if an arbitrator fails to disclose um, where he knows, of course, where he has the knowledge that a lawyer appearing before him is his follower, and then he goes ahead to rule in his favor, then it could amount to partiality. One of the parties could contest that any award coming from the arbitrator in respect of that particular, in respect of him, I mean, in respect of the lawyer being a follower of his on Instagram. So I feel like it amounts to evidential partiality from my own end. Thank you.
Thank you. I see another person has their hand raised. Please share your thoughts.
All right. Good afternoon, sir.
Good
Thank you very
afternoon.
much for the lesson so far. My view is that an arbitrator having a personal Instagram account or any social media account and not disclosing that to a lawyer appearing before him does not affect, is not an evidential, is not a fundamental disclosure or a fundamental fact that will affect the decision of the decision of the arbitrator. And so, as long as it is not fundamental to the case before the arbitrator, it does not in any way or should not in any way affect the rulings of the arbitrator.
Does anyone else have any thoughts? So I would agree with the first person that failed to make such a disclosure could be a ground for vacating. As an arbitrator, you don't want to give any reason for your award to be vacated. So the general rule is if you have to think about it, you should disclose it. If it's something you're pondering, just disclose it. Because otherwise that could undermine the award you've written. Here, go ahead, Tolu.
Yes, good afternoon, sir. Thank you very much.
Yes.
So, regarding this question, what about if the arbitrator doesn't know that probably the lawyer appearing before him is one of his followers on Instagram? Probably he has a huge following. So, would that affect the arbitral award or the proceeding?
The thing comes down to knowledge. You're supposed to make the effort to determine if that is the case. So, but if you don't know, you don't know. So the thing is it becomes a question in terms of like, for example, if let's say let's put this different example. Say this person is a friend of yours on Facebook. You think that would make a difference? Say you have say the limit on Facebook is to have 5,000 friends, and this person in arbitration, one of the parties or the Lord appearing before you is one of those 5,000 people, and you've added this person as a friend on Facebook, not knowing the person, you just add the person. You've added this person about say about 14 years ago, and you I mean, and you haven't had any exchange with the person besides just adding the person as a friend on Facebook. Do you think that would be something that will undermine your award?
Well, I don't think it will undermine my award since I don't have any personal relationship or connection to the person. I've never spoken to the person, and I might not even know or be able to connect the name to the person that is appearing before me.
And how would you think that the opposing counsel would view that in terms
Of
of
course,
seeing that when they go through and look at your Facebook that you have this person as a friend? What do you think they would think?
they will be suspicious of it, of course. I believe they will be suspicious of it.
Does anyone else have any thoughts about that?
Can I say something?
Go ahead.
Well, for me, I agree with what the last person said. If you don't, because somebody may be following you on Instagram or even on Facebook, you may not even know the person is your friend or is your follower, and you have a matter before you for arbitration, and one of the parties, you unknown to you that he's your follower on Instagram, unknown to you. You don't even know him. You've never had any relationship with him or even spoken to him. You don't even know anything about him. So, and then maybe the other party's counsel went and found out that, oh, he's your follower on Instagram. I don't really think that should. Yeah, they may be suspicious. They may be suspicious, but that does not necessarily mean that you have anything to do with that person. It's just your follower on the on Instagram. You may not even know him, so I don't see why in that kind of if it's a follower that you know, you've been relating with him, it's a different case. But this one is your follower. You don't even know he's your follower. So that suspicion, I don't think. I think suspicion, no matter how suspicion, no matter how grave it will be, if you don't provide evidence to prove that suspicion, it goes to nothing. So I don't think if you have such a follower you don't have on, I mean, you don't even know on Instagram, and it's before you're an arbitrator and is appearing before you. I don't think that should affect your, I mean, your work as an arbitrator in that matter. Thank you.
I see Favor also has her hand raised.
Yeah, so I think I have a different perspective to this. So what I would say is, in the case where um, the arbitrator already has the name of the parties, it is important for him to do a background check on the parties involved in the arbitration to see if he has them as followers on his account. So, and then make a disclosure of that. However, there is passive follower and there is active follower. So, active in the sense that there is no engagement, there is no interaction. I can follow you without having anything to do in terms of communication with you. Could just end with liking your post, and that's it. So that's if it's considered to be on
You kind of cut it in and out. Let me pose another scenario to the class. Say, just hypothetically, you go to a church and and you're doing arbitration, and then you see that one of the parties to the arbitration that you never seen before is attending or a member of your own church. Do you think that you need to disclose that? Though you've had no interactions, you just see the person and it comes to your knowledge that the person is a member of your church. Or let's say if you're Muslim, let's say your mosque, or if you're or if you're not don't have any religious affiliation, just your social group, so a club that or like a bar association belong to. You think that you should disclose that, and you weren't aware of that before you made your disclosures, but it came to your knowledge during the process. You think you should disclose that? Is it Joanna?
Can I say something? Okay.
Go ahead.
Okay, good evening, sir. So I just wanted to say, yes, I think that you should disclose it because the other party can insinuate that you guys are working together or there has been some sort of familiarity that can jeopardize the whole case. So just because of the fact that the other party can look at other details, I feel like because of the general rule that you mentioned, that if something you're pondering on, you should disclose it. So I think because of that, you should just disclose it for the sake of fairness. Thank you.
Thank you. Does anyone else have any thoughts? If not, let's go to the next question. When you show up in a hearing, you confront it by an opposing counsel who's not licensed to practice in your state or your country. May a lawyer who's not licensed in your jurisdiction represent a party in arbitration? What are your thoughts? Does anyone have any thoughts about this question they wish to share? Someone who's not licensed in your state or your country is opposing counsel and is representing a party in arbitration.
Good afternoon. Please, may I respond to this?
Go ahead.
Okay, so I think anybody can practice in any jurisdiction when it comes to arbitration. It's not like the regular courts where you have to be licensed in one jurisdiction. So when it comes to arbitration, I think it's a free for all market, irrespective of the nationality. Thank you.
Does anyone else have any other thoughts? And thank you for your comment. Michael, what are your thoughts? And then Joanna. Can you unmute yourself, Michael? Wait, Joanna, can you go ahead?
Okay. So I don't think that it matters because there's ODR now, online dispute resolution. So I know that from anywhere you are, you can be on an arbitration panel or even mediation panel. So you don't necessarily have to be licensed in one jurisdiction to oppose another counsel.
Do you think the arbitrator needs to be licensed?
I don't know. I'm not sure, honestly.
Okay. Okay, let's go back to Michael.
Yeah,
What are your thoughts?
yeah, an arbitrator, to practice an arbitrator, he has to be licensed or belong to an arbitration association at least.
Okay, thank you. Okay, how about was it Siduf? Sorry, I may not be pronouncing your name right. Yeah.
Hello.
Yes, go ahead.
So here, the important thing, being a lawyer is not the important part, but the person has to be a certified arbitrator belonging to an institute, or, for example, let's say the Lagos Multi-Door Courthouse, the Abuja Multi-Door Courthouse, and be a part of the arbitrators there, or maybe a member of the Institute of Chartered Arbitrators, Nigerian Institute of Chartered Arbitrators, or one of those institutions. So being a lawyer from out of state is not the important part, but the person has to be a certified arbitrator in our jurisdiction.
Yes.
Thank you. I see Desmond has his hand raised. Go ahead.
So my opinion, I'm of the opinion that on the question of qualification of an arbitrator to, sit on a matter or appear on behalf of clients, two things guide my opinion. Firstly, is the question of what the parties must have put on in their agreement. We understand that an arbitration clause is separate from the contract itself. So if the arbitration clause provides that the arbitrator must be qualified, and we must also take note of the other angle I'm coming from there. In this sense, an arbitrator is not limited to a lawyer, because in highly complex scenarios, we see technical arbitrations come up in the construction industry and the maritime sector sometimes, where people who are not lawyers are, invited to come and arbitrate over issues. So the question on whether or not the arbitrator should be qualified as an arbitrator, I think that it should be dependent on the agreement of parties as at the time of entering into such agreements or arrangements. Thank you, sir.
Thank you. I see Edith. We're going to do Edith and then Stephen. Go ahead.
Hello.
Yeah, we're listening.
Yes, I quite agree with the last speaker. It should solely be dependent on the party, and then another option is if there's a formal education, like we know all the license, all the certified organizations that do arbitration and all that. But basically, it should be dependent on what the parties have agreed on. Thank you.
Thank you. Stephen?
All right, sir. I want to agree with what the last two speakers have said. So basically, the question of licensing, it's dependent on qualification. So once a person is qualified to practice as a lawyer, and then he has the basic understanding of the procedure, I think he's and then it has been accepted by the party that wants him, or the institution that presented him forward for that particular proceeding, and the question of him being licensed in a particular jurisdiction is immaterial. So this is my take on it. Thank you.
Right. Well,
Please, can I say something? Can I respond? Okay. Well, I would say the last but one commentator, I would agree to an extent, in the sense that in every contract where there's an arbitration clause and the parties, they agree that to an arbitration, they may not necessarily in some arbitration clause, the parties, they don't indicate that it must be a certified arbitrator. Even if they don't say they must be a certified arbitrator, if it is that would arbitrate in respect of the matter, if they have any conflict, provide if they state that they must go for arbitration before an arbitrator, it is implied that such an arbitrator is should be a certified arbitrator, not until the parties will state that it must be a certified or qualified arbitrator. Even if they don't state, it is implied. That's my take on it. Thank you.
Thank you.
Yeah.
Does anyone else have anything they wish to share? If not, I do want to make a comment about a couple of the comments that people have made. I would just want to say, in terms of when thinking about these, understand arbitration is one of the tools in your toolkit. It's another stream of income or a book of business you can have. So arbitration is an important concept. So, for example, I can't say in terms of Nigeria, but in New York, technically arbitration is the practice of law. So I put this question so you can look in your own jurisdiction to make a determination if someone is appearing as counsel, if that person needs to be licensed in your jurisdiction. So, and also in terms of, we talked about ad hoc. So if you're doing ad hoc, depending on what your laws are in your jurisdiction, you don't need to be certified by arbitration institution. If a Microsoft or another business came to you and said, "Hey, we want you to arbitrate this," they're not gonna look to see if you're certified through the Charter Institute of Arbitrators. That's not a requirement. They ad hoc, but if you're going through arbitrator tribunal or what we call institution, then they want you to be certified and have their stamp of approval. So this is just something to think about, because look at your rules locally, make that determination, but you don't need to have a specific certification to serve as an arbitrator, but that may be a decision that parties, when they look for arbitrator, they wish to make. So this is a question that I want to pose to people. You as an arbitrator, or say you as an attorney uses artificial intelligence to write their pleadings. An arbitrator uses artificial intelligence to summarize the parties' arguments evidence. The arbitrator uses artificial intelligence to drive his decision. What are your thoughts? This is a question that's going to appear more and more. I know, like, for example, the American Arbitrator Association, I'm an arbitrator on their panel, and they put forth this type of a question. And they also have a process where their arbitration, parties can make a decision if they want artificial intelligence to make the decision, and they would just have an arbitrator review it just to make sure it's an appropriate decision. I see Desmond. Please share your thoughts.
Yes, sir. Thank you so much. So, considering what you just mentioned now, where in New York, where the parties, submit to the AI, and then the counsels or the arbitrators review, I am of the opinion on two things here. First of all, on the lawyer's use of artificial intelligence in writing of pleadings. The key word in the writing of these pleadings has to be due diligence. A lawyer who has decided or an arbitrator or a counsel representing parties in an arbitration matter who has decided to use AI in writing or drafting his pleadings must be sure to double check every case law cited because of the possibility of AI hallucinations. That's one. And then secondly, such lawyer must also be careful, ensuring that the cases are properly cited and not just concocted AI cases. Because I know I was reading somewhere sometime last year where a lawyer at one of the top consulting firms, or one of the top consulting firms had a problem where it was found that they used AI in drafting some things. Now, on the other part, where an arbitrator uses artificial intelligence to summarize parties, arguments, and evidence, as I already on the issue of due diligence, a lawyer using artificial intelligence to summarize, even though this helps the lawyer, and it's not entirely, let's say, evil, because we must learn how to adopt technology. Some disclosures must be made to the client and ensure that the client's confidence and confidentiality is maintained. So that's that. And then finally, on whether an arbitrator using artificial intelligence to draft his decision, ethical implications of this. So when we over rely on AI and submit facts of not yet decided cases, leaving them to an AI without informing parties or counsels on the matter, we are opening room for exposing serious data, sensitive information to a third party. And this may bring a vicarious liability or any tortious liability that may arise towards the arbitrator. And I now have a question on whether using AI. I have a question, please, on whether using AI will now nullify the award. If AI is used and it's eventually found that AI was used in drafting this award, would the award can an award be nullified or annulled or set aside simply because it was seen or it was found to be, drafted by an artificial intelligence, considering that it was your thought process, it was your mind, your independent analytical mind that provided the prompts of whatever the AI, ended up bringing out. Thank you so much, sir.
Okay. I will pose that question to the class. Edith, go ahead.
Okay, like he said, there is nothing wrong. For me, I believe there's nothing wrong in using AI for all the analysis, including the pleadings or the argument or evidence. There's nothing wrong with using AI. But even most times when you use AI for some documents, it will also tell you to make sure to cross-check. You need to cross-check, you need to check, you need to do your own due diligence to make sure that everything cited, especially the cases or sections of sections cited in the document, you need to make sure they align, they are correct, because AI has the hallucinating part of it. Not everything AI says is true. So there's nothing wrong with using AI to go through your informations or find evidence or arrange pleadings or anything. But where it would be wrong is when the lawyer fails to do his or her due diligence. Thank you.
Christopher, and then Stephen.
Yes. Um,
Thank you. I just want to make some comments rather. Using AI for research, I believe that in this kind of precedent, and this precedent, we don't manufacture thing out of the air. For example, there is no case that is new. It's just new individuals. That's why we have this precedent where we get to go to maybe other cases that we have handled or other things, and then maybe get it and maybe change some things that were aligned to the issue at hand. AI does not know the fact of issue. We as human beings know the fact of issue. But where there is technicality in those issues, I think that's where we get to like make at it in a way where AI takes the first position in any issue. And at the end of the day, you can't really make some clear conscience judgments or awards. If AI makes an award and it's just like a computer deciding what's happened in real life, I don't know if you're getting my point here, but what I'm just trying to say is that I believe AI should be a last resort when it comes to issues like arbitrations and everything, because the both parties know what happened.
Yes, understood. Thank you for your comment.
And the person should.
Can I say something too, please?
Go ahead.
Yeah. AI, I think what AI does, AI helps, it helps the users in facilitating their work. Yeah. So a lawyer or the arbitrator can use AI to, to quicken, to facilitate the work, you are doing. So if the arbitrator is writing his decision, goes to AI and get some information there to help him, write the award with speed, it's okay. The same thing with the lawyer too, in writing his pleadings. If he uses AI to summarize or write the pleadings, to write the pleadings, it's okay. But the important thing, okay, like the other speaker just said, that even we in litigation, we go to precedents, read facts of case, read some cases. If the ratios are similar to what the one we are handling, or the facts are similar, we borrow information from there to use. So it is, I would say it is not new, but the most important thing is for the lawyer and the arbitrator to do the due diligence, to ensure, because AI, they are not humans. Most of the things they are giving, the information they are giving, still humans are factored all those things into AI. And AI is not 100% and correct. So it's for us to do the new due diligence and ensure that whatever the arbitration should ensure that whatever decision, it is what the parties agreed, should not deviate. Do not go, because he's using AI, then he goes and deviate from what the party said. The same thing with the lawyers. The fact, your client, they are giving out you the facts of the case. Even if you are employing AI to assist you in writing the plea, you must do your due diligence and ensure that whatever the final pleadings you are giving is what the parties have given you. So I don't think using AI, we are going out of the box. It's just to ensure that we do our due diligence and ensure that whatever we come out at the end of the day is from the facts, the fact the client has given us, or like the arbitrator, is from the fact before it that the arbitrator we used to write the award. Thank you.
Thank you. Stephen?
All right. Thank you very much, sir. I largely agree with all the speakers of this question. I also want to particularly point that Like Nigeria Rule 14 and 16, or the rules of professional conduct for legal practitioners, talked about representing a lawyer, a lawyer representing a client. Rule 14 talks about devotion and dedication to the cause of the client, while Rule 16 specified a lawyer representing a client competent. So it all, goes down to the due diligence they're talking about. So the use of AI itself is not the problem. It only become a problem when there is over reliance on it, and that over reliance now produces a result that is inaccurate or inadequate. So that's where it becomes an ethical problem. So if a lawyer adopts the use of AI in drafting pleadings or writing the agreement or decision, it's not bad. But if the decision he wrote or whatever he has done with the use of AI now it's now incoherent with what the parties have agreed, or with now affect his work in respect of representing the client competently, or representing or proceeding competently, then it becomes an ethical problem. So then, regardless of any problem, then use of AI is not a problem. Thank you.
All right, Charity, do you wish to say something? All right, thank you. One of the things I would give a statement in regards to is when considering this, think about the confidentiality. There's different AIs have different standards. Some are not confidential in terms of your use of it. And another is if the parties hire you as the arbitrator, would the parties really want the AI to the drafting of the decision or to do much of the heavy lifting of you reaching a decision? And if you use it, you want to make sure you disclose that to the parties. So AI is something that's very much taking a more and more important role in our practice as lawyers, and also for some arbitrators, um, their how they manage their case. But it was another question I just wanted to pose to you just to think about. So this one is the last question. Arbitrator lists his testimonies, endorsements, and the lawyers are now representing before the arbitrator did not disclose the testimony or endorsement, and the motion to vacate on evidential partiality. Will a defense succeed based on the argument that the challenging party had constructive notice of the testimonial or endorsement? Does anyone have any comment that they wish to make about this last ethical issue posed in question? Does anyone have any brief comment? If not, I would just say again that you have to do your due diligence in terms of making sure you have anything you need to disclose. If you have to think about it, you should disclose. So we're now in another part. We're almost toward the end. This is 20 mistakes attorneys make in arbitration. The 20 mistakes was posed by arbitrator and mediator Harold Coleman, who worked with the American Arbitration Association along with mediate.com. And this is what he posed. Said 5 pre-hearing mistakes and how to avoid them. Number 1, postponing itemization and damages and grounds for recovery. Number 2, fear of committing to a schedule. 3, bury exhibits and not having a core book of documents. 4, not disclosing demonstrative or summary exhibits. Not requesting the form of award. 10 evidentiary hearing mistakes and how to avoid them. Number 1, failing to provide a roadmap of the case, so an arbitrator can listen effectively. Number 2, not correlating the elements of proof in order of the witnesses. Again, for your audience, this is the arbitrator. You want to make sure your arbitrator is listening effectively. Number 3, repeating the direct examination on cross-examination. Again, repetitive. 4, surprise exhibits. As a attorney or counsel to one side, you want to make sure your evidence gets in. Surprise, there may be an issue if that even gets admitted. And then what effect would that have on the case if it doesn't get admitted? Number 5, not provide a clear, concise calculation of damages. Again, make it easy for the arbitrator. 6, not specifying all related relief requested. You want to be clear of the relief you're requesting. Number 7, not listening or reacting to the arbitrator's questions. Again, you want to tailor your presentation to the arbitrator as a counsel. 8, failing to notice that the arbitrator does not understand the testimony. Number 9, using rebuttal to repeat earlier testimony. 10, making a closing statement that does not match the opening or fails to highlight the most important exhibits or testimonies. 5, post-hearing mistakes and how to avoid them. Adding new claims of relief, including new arguments in post-hearing briefs. 3, not highlighting the most important exhibits and testimony in a post-hearing brief. 4, not providing the arbitrator with a proposed award. 5, leaving a hearing without a closing date. Does anyone have any questions or comments they want to make about these 5 mistakes attorneys make in arbitration? Does anyone have any mistakes that they think would be beneficial to add for us to consider? If not, we're going to go to the last part, which unconscious psychological influences in addressing them. I want everyone to take a look at these 2 pictures, the one on the left and the one on the right. And I want you to tell me first, the one on the left, what do you see when you look at the one on the left? All right, please share with me what you think. The one on the left, what do you see?
See a woman who is walking away, like her back is turned.
You
That's
see,
what I
you see a what?
It's like walking away. She's giving the cold shoulder.
Okay.
Yeah.
What does anyone else see?
Someone thinking. Sorry, I didn't take permission. Someone thinking, or it's hand akimbo, kind of.
Okay. Anyone else see anything? Again, the one on the left.
Can I say something?
Go ahead.
Yeah, well, the first picture there is, yeah, I agree. It's someone thinking maybe it's kind of, I'm trying to think, what is he thinking about? From the hands akimbo and the facial expression, it's like maybe he's expressing regrets within him about about the matter. Maybe he could have agreed for the matter to go on, or maybe he wouldn't have objected. So it's kind of, that's just what comes to my mind. And then this other second, the next picture there is showing they are facing each other. It's like they are facing each other. They are ready. They are ready to talk. There's no, they are coming close to each other. That means they are kind of in the same direction. They are willing to discuss. Yeah, that's just the picture I'm getting from the second one. They are coming together, closer to each other, maybe to resolve the conflict. Thank you.
Okay. I say either.
From what I can see here, the person on the left is indifferent. She's not ready to resolve, he or she is not ready to resolve whatever issue that is he or she is being confronted with. He's not ready to dialogue or discuss or anything. While the other picture where we have two faces are people that are now open to communication, they're ready to dialogue, they're ready to talk about the issues before them.
Okay. How about I see another person was Ayana. I don't know if I'm pronouncing the name right.
Okay, so the one on the left, uninterested in the process, while the ones on the right are ready to discuss, like others have said.
Okay. All right. So I just want to point out to you because we have about 6 minutes or 7 minutes left. So the one on the left, the first person said that they saw a woman with her head turned away, and some people may see an older woman um thinking deeply about an issue. So, and then the one on the right, some people may look and see two people face to face. And some people may look and see a light there or a candle holder. You see how people can look at the same thing and come to different conclusions. So this is just a thought exercise to have you think. So I'm gonna go to this right here. One of the last slides. So unconscious bias. So the way the brain works, we have so much information we have to process every day. I remember reading that we can process in a day easily the equivalent of about 10 movies in a day. I mean, in millions of gigabytes of information or billions possibly over the course of our lifetime. So some of the things that we think about or are subconscious. And sometimes we process those in our dreams. And that's why sometimes advertising is so effective. It gets to us to think things that are not conscious to us, but subconscious. So in terms of arbitration, we have sometimes we have these mental shortcuts that could be cause cognitive bias. and I want to bring them to your attention so you can be a more effective arbitrator. One is I knew it all along bias. They call it hindsight bias. Number two is the anchoring bias. Overly relying on the first piece of information we receive. I took a negotiation course through the through the American Bar Association years ago. They had a negotiation institute, and one of the things that they taught us is the person who proposes the first offer sets the tone for the resolution. Number three, framing bias. Our decisions can be influenced by the presentation. Number four, availability bias. Judging likelihood based on examples that easily come to mind. So you may look at someone and say, but you may look at someone who's a party before you, and that reminds you of someone else you've known when you were in school. Or you may be influenced by what you saw in the news the other day. What's before you may be similar to that. That's availability bias. Confirmation bias is number five. Favor information that confirms our existing belief. And that's one of the things that the algorithm of the internet does. It is when you go to search stuff, and even when you don't search stuff, it'll just present itself. And even here in the United States, they have things where a person can be watching one TV program in one house and right next door, and they get different commercials because they're tailoring the information to us. So confirmation is information confirming our existing beliefs, where we seek out that information. And then attitudinal bias based upon our own background and our own experience. In improving decision making, this is the last part. Just one more slide. So I think we only have 2 minutes left remaining, so I'm going to try to read this. Identifying why you may be wrong. What important information that you consider that may go the other way. Consult your co-arbitrators if you're on a panel. Create a checklist of columns for each party and list the facts that flavor that party. Create a checklist listing the claims and elements of each claim and review how and whether they have been met, looking at it from each side perspective. Reduce your reliance on your memory. Look for record citations for all of the important facts. Replay how you reach your conclusion and think about what evidence you rejected and why. Write down your reasoning, even if issuing a bare bones award. Identify any sufficient evidence that will be inadmissible or unreliable, which may have influenced you. Consider how the outcome would be different without the evidence. Focus on the biases, whether conscious or unconscious, and whether you have been influenced by them. Don't take too many cases where your quality of work suffers. Leave time to sleep on the work so you can go back and review it with fresh eyes. Consider what you have done, consider what you would have needed to have been presented to you to come to the opposite conclusion, and consider whether in fact such evidence was presented. Ask yourself what the losing party will feel like if you overlook them in your analysis. Consider if somebody were to conclude the other way, what would he or she write? Where and how would he differ? Any thoughts or questions? Thank you for your time.
So I have a question, please.
Go
When
ahead.
you were talking about types of awards, I didn't understand what you meant by when attorney's fees are at stake. Is that a type of award as well? I didn't get the explanation.
So in terms of awards involving attorney fees, so sometimes attorneys may ask for attorney fees. So sometime arbitrators separate their main award and then they decide the in terms of attorney fees and costs based upon who wins the award, or if it needs to be spread over all. So one could be one could be the final award, and then you also put forth the award with the cost, and then sometimes you combine the two. So those can be two separate awards. It could be one where just saying this is the side that wins, and this side that loses, reason or bare bones. And then after you make that conclusion, you can go ahead and decide, have the parties make additional submissions about the costs, and the attorney fees, or you can have them do it all at the same time. And you as arbitrating the parties can come to a conclusion. That's why in terms of um, in terms of the beginning, in terms of the case management order, you want to lay out how the parties want you to do it and how you're willing to do it. So the more work you put in at the beginning, the less work you have to do at the end. So if the parties already know, they can look at that case management order and say, this is our dates, this is what we need to do, this is what I can expect from the arbitrator, and this is what I can expect from the arbitrator. Any other questions, concerns, or thoughts? If not, I want to thank everyone for their time and their participation.
Thank you very much, Mr. Aaron, for your time. Thank you for this insightful session. We do not take any of it for granted. Thank you for taking out time from your busy schedule. Thank you very much. And to all our participants, we say thank you very much for coming. I see that I was going to ask whether there was any question, whether there's anybody that has any question, but then I think this question has been asked. And Mr. Aaron, you've engaged all attendees well, because instead of them asking questions, you were the one asking questions, and you made it very, very interactive. So thank you very much, Mr. Aaron.
You're welcome.
So for next week, link is going to be sent. Our class for next week, links are going to be sent. But however, the recording for this session is going to be live later today. So we are going to get the link for people that want to rewatch and learn something new. And I hope everybody has time to jot one or two things down and take things away. Thank you very much for your time. Thank you, Mr. Aaron. I'll be in your WhatsApp to give you a proper thank you. Thank you very much, everybody, and do have a beautiful weekend.